Okay, we're live. 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 All you need is
All right, welcome everybody to House Energy and Digital Infrastructure. It's Thursday, January 15th, and we are continuing our discussion of H 527, an act relating to extending the sunset of 30 BSA, Section 248A. We are here today with Annette Smith from Vermonters for a Clean Environment. I'm Representative Kathleen James from Manchester.
Richard Bailey, Lamoille 2.
Chris Morrow, Wyndham, Windsor, Bennington.
Michael Southwood, Caledonia 2.
Christopher Howland, Rutland 4.
Graham Kleffner, Tiverton 13, Burlington.
Great. And Rep Campbell is on his way. I don't know where Rep Torrey is, and Rep Sebelia is out of town. In the room, who do we have?
Claire Buckley from Leonine Public Affairs for CTIA.
John Brabant, Vermonters for a Clean Environment.
Allison Despatsy, Vermonters for a Clean Environment.
Dana Lee Perry, the Craftsman Group.
Great. And
Scott Campbell from St. Johnsbury.
all right. For the record, thank you for joining us.
Thank you for having me. My name is Annette Smith. I'm Executive Director of Vermonters for a Clean Environment. I don't think I've been before this committee before. Brief introduction. Vermonters for a Clean Environment was formed in 1999 to address a natural gas power plant and pipeline project proposed for Rutland and Bennington counties. I never expected to continue doing this work. 26 years later, my first time in this building was before the House Commerce Committee on Section 248 in January 2000, when there was a proposal to eliminate the need clause from Section 248 in order to enable the gas power plants. So I have a long history. What we do at Vermonters for a Clean Environment is to help our communities have a say in what goes on in our communities, hold corporations accountable for their actions in our communities. And overall, we prefer collaboration to litigation. And I've tried to bring people together for these stakeholder groups. I will also add, I'm not a lawyer. And so I want to make that very clear because I was brought under criminal investigation by the Attorney General's office in 2016, alleging that by assisting people at the Public Utility Commission, I was practicing law without a license. And so I don't give advice. I don't give legal advice. I'm not here to give you legal advice. And I do not do that when I assist people with the Public Utility Commission. What I'm going to do today is to answer the question, what is Section 248A? From the perspective of the community and the people who live there. And so I'm going to take you through the process, just as I have done in numerous towns. I've presented to the Manchester Select Board, to the Marshfield Select Board. I've done this a number of times. It is a very extensive process. So I hope to get through it all. And what I'd like to do, because I want to make this as understandable as possible, is I would like the three of you to be a select board, 3-member select board that meets once a month. The three of you are a quorum of your 5-member planning commission. And Representative James, you are the staff person for the Regional Planning Commission. And it's your job to deal with the project review committee that meets once a month. You meet once a month. And the project review committee that reviews the advance notices and the petitions then makes recommendations that have to be approved by the full commission. And I was going to have the citizens be those other two legislators. So I guess if Senator Campbell comes back, he can be one of them. But we've got a couple citizens here. So we will have Allison be the neighbor who is very concerned about the health effects because tower is proposed 500 feet from her house. And she has small children, one of whom's autistic, and they have health issues, and this is very concerning. And John is very worried. He has a really nice house with gorgeous mountain views, and the tower would be between his house and the mountain views. And he's really wealthy too. And so he's concerned about his property values. And Representative Howland, you've been chair of this select board for 50 years. Representative Klebner, you're the leasing landowner. You're on the select board, but you're leasing the site for the tower. And Representative Torrey, you're relatively new to the select board, and you're a woman. So, okay, and I'm not asking you to do role play. I'm trying to set the table for who the players are in this process. So I've given you a set of slides. This is not a PowerPoint presentation. These are reference slides. You've asked a lot of questions. There are a lot of answers in here. I may refer to them. I also found my testimony from 2023 and from 2020. And I've provided that in one sheet of paper, which you can access online and have links in it. It also has links to all of the contested cases in the last few years. So we are here to talk about Section 248A. And Section 248A is one of the most prescriptive statutes that we have. And so when I am assisting a community, my answer is when in doubt, go to the statute. So your community has received an advance notice for a 140-foot telecom tower that is in an area that's very close to someone's home and has an aesthetic effect, and you have never heard of Section 248A. You have no experience with PUC. I have never been to a community that has any experience with PUC. So this is all new to everyone. And so your select board meets once a month. Well, you get the advance notice. Do you put it on the agenda? Some towns do, sometimes don't. But the citizens who got the advance notice realize maybe they found me. All right, well, you need to see that, because what happens on the town level in the advance notice period is really critical to the whole process. It's a process where it is not about the PUC at all. PUC doesn't pay any attention to the advance notices, except that they have a portal and on ePUC where comments can be submitted. And those comments are to the developer, not to the PUC. But everybody's like, well, we want to tell the PUC what we think it is. No, in the advance notice, you're just telling the developer. So it's the opportunity for the community and the developer to work together. Now, if you do nothing, nothing happens, because the developer doesn't come to you. You've gotten this paperwork. That's all you've gotten. And so it's entirely on the responsibility of the municipality to reach out and take action. And so one of the first things that I do is I go to the statute and I do a search for municipal. The word municipal appears 28 times. Now, the standard reaction of a select board is, there's nothing we can do, decided to staple. Well, that's actually not true. As you heard when Ellen took you through the statute, the municipality can, during the advance notice days, ask the developer to attend a meeting. You can ask the developer or ask the Department of Public Service to attend the meeting so that they hear what happens at the meeting and they can use that to assist them in their comments. You can ask the Department of Public Service during the advance notice period to hire an outside expert to look at co-location and issues like that. I've seen one town do that. But unless you do that, and nobody knows who to contact or what to do, but you do get in the advance notice packet a piece of paper called Rights and Opportunities that actually is a very good review of what is in the statute that the municipal legislative bodies can do. May of the commencement of 60-day notice process, request the department at petitioner's expense, retain experts, attend a public hearing during the 60-day notice period, and have that based on their comments. And so the planning commission, what is your role? well, I don't know, we want a tower there. Uh, people want more cell service, but wait a minute, doesn't the neighbors, God, this will really do a number on them. Um, no, your role is to evaluate your town plan. This is not an opinion piece. This is to go through your town plan. Does it comply or doesn't it? What's the role of your telecom bylaw? Representative Bailey, you've been on this planning commission for 25 years. So you've been around since the beginning of the section 248A. The bylaw doesn't apply. And you asked the other day about zoning. Well, okay, zoning doesn't apply, but as the statute says, your recommendation can be based on the town plan and also on your telecommunications bylaw. That is very unclear. I have heard from at least 3 different longtime planners. Our bylaw is superseded and we can't talk about it. Now, you can't you are required to give a permit based on your bylaw, but the standards that a lot of towns have in place for your bylaw do matter. So, you could have a planning commission working on reviewing your bylaw. You could have a select board. Not sure what your role is at this point. You can hold a public meeting. That's really what you want to do. The town that I've worked with who has done it the best is Worcester. They got an application from Industrial Tower and Wireless. They found me somehow. And I said, well, a lot of times what happens is the town invites in the company and they just kind of take over the meeting. And I call it a dog and pony show. I've been through so many of these things on so many issues. So I really find it hard to sit through them. But what's best to do is hold your public meeting first with the public and hear what their questions are and hear what the issues are. And then hold your next meeting and invite the applicant, but don't let them take over the meeting. You run the meeting and ask them the questions that you have and that have been generated at your meeting. And they did that. And it was a much better experience than what I've seen. For instance, when Verizon came to Manchester for a tower, people were very frustrated by what typically happens is that they take a long time in their presentation. I sat through one in Teignmouth last summer. It was really, really hard to sit through. They go on and on and on. I said, I need to set the time limit at 30 minutes because they don't need to chew up that much time. Oh no, they just take forever to go through the materials. It was 90 degrees. It was a hot, humid day. There was no air conditioning. And then people would ask questions and then they'd take another long period of time to answer the questions. And so the public's voice doesn't get heard. Some towns limit that you can only ask questions. You can't make statements. People want the opportunity to share the information they have. Oh, and by the way, Allison, the PUC doesn't care about health issues. You can't talk about health issues. That's preempted. John, the PUC doesn't look at property values. So even though that you might have evidence that they reduce property values 15 or 20%, sorry, that's not of interest. Okay. And I'm being a little chaotic here because it's a little chaotic at this point. Allison's freaked out. She's not sleeping. She is like, I'm going to have to move and I don't know where I'm going to move to. It's very stressful for the people who are affected. And I've seen young families, I've seen elderly people with heart issues who lived in the same house for 50 years. It is something that is done without any advance notice to the community. Now, you asked a question yesterday about leases and landowner leases. These companies go out prospecting for sites and they'll get turned down by a lot of landowners. And then they'll find a landowner who will lease the site. Now, there's no transparency around that. I have concerns about the equity of these leases, and are people being taken advantage of? Or some people getting $2,000 and some people getting? I heard in one case in one town that 2 or 3 landowners turned down over $200,000. Now, I don't know if that's for the whole life of the thing or if it's for a month, but the case in Worcester was interesting and unique, that after hearing the community input, the landowner chose not to proceed because the tower was about 350 feet from the home of a man who had a brain damaged daughter. And the community rallied around this neighbor. And so even though you couldn't talk about the health issues, everybody realized this was just too close, including the landowner who had a lawyer, his own lawyer, look at the lease And so he got out of it. That was industrial tower and wireless. Since then, I'm aware of two situations where the leasing landowner has said they wanted to get out of the lease, but there were penalties in it that they would have to pay all the penalties, and that there was no way they could get out of the lease. So, I've seen leases for solar projects and wind projects, and I look at them and I think nobody should really sign these without a lawyer looking at them, because they're giving away rights. The leases all protect the rights of the company and not they don't have any protections for the rights of the people. I'm also aware of 3 situations at least where the neighbors who have come out in opposition to the tower have been subject to threats and bullying by the leasing landowner. And some of it is pretty scary. There's one instance with somebody had to take out a restraining order or something. I mean, it sets up a community dynamic, all of which is done without any collaboration with the community. These companies seem totally unwilling to come in advance and meet with the community and say, hey, we recognize that you could use some cell service here. We'd like to do a tower. Could we work together? That is not part of the equation at all. And I want to respond to what Ryan said about how collaborative AT&T is yesterday. I'll set that aside, but I will come back to it. So now we are at the advance notice phase. We've had a public hearing. We've had the presentation by the developer. The public has said things. And then in best case scenario, the planning commission has had a chance to review your plan. Now you only meet once a month, and this is a 60-day notice period. And well, you didn't even really realize what you were supposed to do at your first meeting. And so now you have another meeting. And as long as there's a process going on in the town level, it does appear that the companies will hold off on filing. The 60-day notice period means that they cannot file a petition up until day 61. But they have from then until 180 days to file their petition. And at 181 days, the advance notice expires. And then, so I've seen some petitions filed on day 179. I've seen some filed on day 61. If nothing happens on the town level, you're more likely to get it on day 61. And if something happens on the town level, like in Wallingford right now, there's an advance notice and they're not holding the hearing until January 20th. And I think it's on day 70 something. So I haven't seen a petition yet, but if they file, then it'll probably be after they've had a chance to get comments from the town. Now the state agencies also.
Annette, I'm sorry, we lost your screen.
I know, and it just says workplace, and it's going on and on. Isn't technology fun?
The document that you have up on the screen that's available to show, what you can do. Did you submit that assessment? I didn't see it in your packet.
It's all in this, everything that I'm showing you in the links is all linked. For instance, there's a page of links.
It'd be helpful if you could submit that document separately, just for folks who might not have the time to check out all the links.
Yeah, it says telecom databases, and it has the
Okay.
So if you want to hold on a minute, I'll see if I can get back on the Zoom. So the Agency of Natural Resources always submits comments, but they do not submit them in the PUC. So if I want to get them and share them with the citizens, I write to Billy Coster, and Billy will send them to me. I don't know why. I guess I've lost the internet.
Wait for a sec. Let me get back on if you want.
There's no internet. So
Alex, is our room okay?
they have, so okay.
Yeah.
So
Okay, I'm on.
I got kicked off. So
Okay.
I think I'm on now. So I don't know what the other state agencies do, but often it's important to find out what the agency's position is. I will say that the agency is doing, I would say, a bare minimum on these cases. And so it is not something that you can count on. I've been very disappointed in all the state agencies in these cases. Kicked off again. Could not be joined. Try moving to the closed wireless router. The Department of Historic Preservation is, if there's artifacts on the ground, you'll get some activity there, it's archaeological, but in terms of protecting our state's historic resources for scenic aspects, it's just not happening. So the advance notice phase, trying to avoid technical difficulties. Well, not each of mine, so, oh well, we'll try again in a minute. At some point, the advance notice phase will end. You may have sent your comments. I have lined up to show you the comments that Tim has sent that said it doesn't comply with our town plan or our bylaw, and so the project should be denied. And they filed anyway. And so then the petition gets filed. Now, what's a petition? Many times in dealing with not only these telecom projects, but also in the solar projects, people will say they speak a different language. Petition is an application. There are many parts of this PUC process that are so foreign to the public. The very first solar case we were involved in, the neighbors had intervened on their own. And then they got a call from their attorney, from the attorney for the developer, and said, well, you missed your deadline for pre-filed testimony. And they said, well, the schedule said for non-petitioning parties to submit pre-filed testimony. And she said, we've always been called interveners. We didn't know that meant us. There are many examples.
Helps get on, but I don't have your.
Probably one, but thanks.
Okay.
So when the petition is filed, that's when the first 30-day process happens. So we've been through the advance notice process. It is very difficult on the community level to do what is required within that period, or to even get people to do anything. You have a citizens group who is very concerned and maybe going to every meeting, and there may be special meetings. Your planning commission may actually be working together to try and come up with something. But on the other hand, to do that in a time frame, because you may be exchanging drafts and things, which is kind of a violation of the open meeting law, but hey, at least you're trying. And so then let's say you get your comments to the petitioner, and then the petition gets filed, and you are then waiting for the hearing officer, Greg Faber, who is the hearing officer on every case, to determine that it's complete. Once it's complete, then that's when the 30-day clock starts ticking. And
Another 30 days.
yeah, so you've been in the 60-day period. The advance notice is over. Now it's in the 30-day period. And that's where it gets really confusing. And one of the things that has happened in the last few years is we have a lot more contested cases. When I was before the prior committee in 2023, there were maybe one or two, maybe one contested case. Up until that point, there just hadn't been any. There was one in 2017. And it was around that time that AT&T was doing a big build out on the FirstNet. And AT&T seemed to be doing everything possible to avoid having a contested case. And so I was involved in a number of towns where they found that the project was way too close to schools, people's homes, and they didn't comply with the town plan. and AT&T would find another old location. Then Granville came along, and that didn't happen. That became hard fought. You were told yesterday by AT&T that was the first net project that wasn't done. They got their CPG in 2024, so that project is done. The project that is out there is Pownell, and that one is a very upsetting project from my perspective, what it's doing to the neighbors. So we have not had an opportunity to understand the pitfalls of Section 248A until the last few years, when there have been more contested cases. So we've now had Enosburg, and Enosburg was denied by the PUC based on the recommendation of the Regional Planning Commission. All right. Does the Regional Planning Commission intervene? Does the town intervene? Because the statute says you submit recommendations. So the Regional Planning Commission didn't intervene. They submitted a recommendation. The statute doesn't say when the recommendations have to be filed. Now on EPUC, there's a schedule, and the schedule will say at the 30-day date, so you'll know when the date is, comments. Sometimes it'll say, as Greg did yesterday, comments, motions to intervene, notices of intervention. But nowhere does it refer to recommendations, which is what's in the statute. And so what has come out of these recent contested cases, including Westmore and Tinmouth, is that there is no process set up for what to do with the town's recommendations. EPUC has a drop-down menu where you click on Select All, and you can file your motions to intervene, you can file comments, you can file public comment, but nowhere does it say recommendations. So some towns will intervene, some towns won't. Regional Planning Commissions never intervene, but the statutory citation is that these recommendations will be given substantial deference, that create a rebuttable presumption unless there is some greater public good that can be found. So what we found in the Westmore case was that the town, which had a select board where the leasing landowner was on the select board, creating a very challenging situation and social dynamics in the town, that they did not intervene, but the planning commission finally did get it together and filed their what they called testimony. And then the select board read what they had, the evaluation of the compliance with the town plan and the telecom bylaw. And then the 4 members of the select board, by then they had expanded the select board, 4 members of them voted to recommend to deny the tower because it didn't comply. The planning commission tried to intervene after the 30-day period and was denied. The applicant then filed a motion in limine to strike all the public comment because the recommendation had been filed as a public comment because there's no place in the drop-down menu to put it. And so we all realize there's no process for filing recommendations. There's nothing in any of the guidance documents of the PUC that say what the deadline is, or that the 30 days is a deadline for recommendations. Then in the Tinmouth case, because they learned from Westmore, they did it all right. They got their advance notice comment to the town, from the town to the PUC. Then they got their recommendation in by day 30, recommended. It did not comply with our town plan. It did not comply with our bylaw, recommend denying it. And the applicant got very upset, saying, but there's no process for responding to this. So both sides, and both of these were industrial tower and wireless, both sides have said there's no process at the PUC for how to deal with these recommendations, yet they are given substantial deference. Now, this is one part of the problem, but I want to highlight it because as you are thinking about extending it or making it permanent, it's really important to understand that this problem has only surfaced in the last few months and even within the last year, and that it was not realized before because the system hadn't been tested. Now, Greg said yesterday that because it sunsets every 3 years, they haven't even done rulemaking. And that's really the problem, is that because the statute doesn't address the process for recommendations. And even though there are guidance documents, if you do a search of them, the word recommendation doesn't even show up. How do you know? How does the town know that they must get the recommendation in by day 30, even if they can, because is it enough time if they just didn't know to do anything in the advance notice period and then they have to get a recommendation in? I mean, it's a system that is not well thought out or well designed to make it possible for a town to participate in the way that the statute envisioned. I want to give a lot of credit, I think, to the Senate Finance Committee, which has jurisdiction over this in the Senate, for, I think they are the ones that have been responsible for assuring that the towns have a voice in this process. However, I'm here to tell you that process that's set out in the statute is not working, and it has to be fixed. Now, that's aside from the larger problem with the rest of the Public Utility Commission process. I think you may have been given, or Ellen had, the document that is the flow chart of what the process is at the PUC. So I'm going to take you through that now. The petition's filed. What happens next? You get to day 30. It's the deadline for notices of intervention. So let's say everybody's on the ball and you get your notices of intervention. The town gets its recommendation, but there's also a comment that's separate from the recommendation. The comment needs to show that the project raises substantive issues that require a hearing. That's what I always thought the 30-day period was for. So are there issues? And you can't just say, we want a hearing. And you can't just say, well, this has got problems. And you need to be able to present something that shows that you are prepared to put on a case. And they can deny a hearing or they can grant a hearing. And so then the other thing that happens is the motions to intervene. The citizens file motions to intervene. The town has a form, they can file a notice of intervention. And the Select Board and the Planning Commission are two separate entities. In Rochester, on Monday, we had the deadline of 30 days. The town and the Select Board each filed their own notice of intervention. Now, the town, when you're dealing with boards, who's going to represent the Select Board and the Planning Commission? You have to figure that out. Or should the town hire a lawyer? Okay, well, who has $20,000 to $50,000 kicking in? Is that in the budget? Because that's what this process costs. This is a very legalistic process. Motion to intervene has a form too. Motion to intervene form is a little challenging. It has 2 boxes on the front and 2 boxes on the back. And the 2 boxes on the front say, for parties of right, and you can name the statute or you can just list things. But this is very rare. And I have no idea what a party of right is. So I just tell people to turn on the back. And then the 2 boxes on the top are, you can intervene by statute, if you can figure out the statute, or you can intervene by issue. So you can write a list. I want to intervene on aesthetics. Now, neighbors only get standing on aesthetics and compliance with the municipal and regional plan. I think somebody yesterday mentioned orderly development of the region, but that actually is not part of Section 248A. It is part of Section 248. Oh, I should add that in Section 248, there is an A, but it's in parentheses. So you have Section 248A in little parentheses, and you also have Section 248A, which is a separate part of statute. This is very confusing to people. The form for filing a motion to intervene has a limited amount of space, so you can add a narrative. And so I handled a lot of these on Monday where people write a narrative that talks about their opposition to the project. And I have to explain, no, this is about your property interest. So people complain about NIMBYs. No, you have to be a NIMBY in order to intervene. And you can't talk about property values and you can't talk about health effects. You need to talk about, can you see it from your property? How is your particularized interest affected? And so some people just use the form and state it that way. Some people write a longer narrative, and then you have to file these things. So you go to EPUC and you click on the select all menu, and then you use the drop-down menu, file motion to intervene. But You start filling that out, but then, you have to add a person to the system. So you leave that page, and I have had phone calls from people at 3:30 in the afternoon on the day of the deadline, practically in tears. They tried for 2 hours to try and figure out how to file these things. And there's some people who try and do it themselves, and they just get so frustrated. And I have excellent secretarial skills. It doesn't matter who files. You have to create an account too first. So I just say, send them to me and I'll file them for you, because nobody knows who files these things except the clerk. And so I ended up on this crunch deadline, the day of the deadline, if there are people intervening. But then people want to file public comments too. Well, okay, so they go to the public, to the case page, and on the left is something that says public comment. So some people think they should use that, but that doesn't really get, so then instead you use the drop down menu and you click on public comment. And I've had a few people recently say, but I do that, but then it says at the top the case number and all that, and I can't fill it in, but it doesn't say it's there. So how do I know that it's the right case? And I say, if you're starting with the page and you click on public comment, it's okay, it will go to that page. It's one piece of confusion after another after another. So we've gotten public comment, we've gotten the motions to intervene, we've gotten the notice of intervention, and now that we know you have to do your recommendation within 30 days or else the PUC will strike it, what happens next? So now we're going to the actual process. The
I know. I'm sure.
hearing officer will issue an order setting a date for a scheduling conference. The scheduling conference is preceded by, hopefully, not always, but the applicant sends out a draft schedule. Now, you heard some things yesterday about the shot clock. And these companies are claiming that there's a 150-day shot clock. And Greg explained that very well yesterday. So he's like, well, but Industrial Tower and Wireless, which is a new company to Vermont, has sued the PUC 3 times in the Ira case, the Enosburg case, and the Westmore case, while the case is going on, which is very disconcerting to the public. Now the PUC is being sued in federal court by this company, saying they're not acting fast enough, and so you better issue this permit for us because they're not doing it according to the law. The scheduling conference is often a schedule proposed by the applicant that is so ridiculous that nobody could do it. There would be no due process. I've seen a couple of those recently. And then the Department of Public Service will come up with a schedule, and the citizens don't really know what a schedule looks like or what it should look like. Now, there's standards that you see that there's generally 2 weeks or a week in between the different steps. And so if I get the schedule, I'll look at it, I'll look at other schedules, we'll suggest something that is reasonable. If the parties all agree on the schedule, which does happen, the scheduling conference is 5 minutes. If the parties don't agree, which is very common in these telecom cases, because the companies want this aggressive schedule that is unrealistic, and the neighbors want a reasonable schedule, or the town, and so then Greg Faber will say, well, if you can't agree on something, submit your separate schedules, and we will decide. I'll decide. He recently accepted a schedule that the neighboring landowner, who's the only party affected, vehemently opposed. I've never seen such a ridiculous schedule in my life. The Department of Public Service agreed with the applicant. It was the applicant's schedule. And it was accepted by Greg Faber. And it was so absurd that within no time, the applicant filed a motion to change schedule. Motion to change schedule. Well, that has a rule that if you're going to file a motion to change schedule, it has to be 3 days in advance of the deadline. I have been involved in so many of these cases where the neighbors are on the edge of their seat saying, well, the motion to change schedule was filed, but we don't, and it's often not from the neighbors, it's often from the developer or the applicant or even DPS. And they don't know if the ruling is going to come through. And often the ruling on the motion to change schedule comes after the deadline. So the citizens go ahead and file. The department often just doesn't. If they file the motion to change schedule, there was one case where in Westmore, on the day that the pre-filed testimony was due, the attorney for the Department of Public Service filed a motion to change schedule on the same day it was due. So the citizens don't know, well, do we continue or what do we do? And so they went ahead and met the deadline. And then a little while later, Greg Faber gave the extension. So there could have been 2 more weeks for everybody, but it's a very stressful process. Okay, so now we have a schedule. Great. What's the schedule involved? The first thing is discovery. What's discovery? Anybody been involved in a court case? Do you know what discovery is?
Yeah, vaguely.
So you have 3 different things. You have interrogatories, so you ask questions. You have request to admit, so admit that the neighbors are going to see this from their house, something like that. And then you have request to produce. Well, the average person has no idea how to write discovery questions. And so a lot of the things that I see are things where I say, well, those are pretty good questions for cross-examination, but they're not really questions for discovery. And in my view, discovery in these cases is really pretty much a waste of time. It also impedes the ability for the people who are affected by it to develop their own case, because now the applicants had, as we've heard, a couple of years to get it together, to get the lease, and they have their boilerplate applications really to make them. And so then the citizens have what they have to put in aesthetics expert witness testimony. Maybe they can find an expert on the town plan. Maybe they have to raise money. Oh, by the way, all these people who got intervention, maybe there are half a dozen of them, they didn't know each other before, but in the scheduling order, they will be told that they have to work together and choose one representative. So all of a sudden, they get to this built community. They get to meet their neighbors, and they have to work together. There may be meeting after meeting after meeting where they have to come together on how to present a unified face. Oh, if they want to hire a lawyer, see if they have any 10 or 20,000 or more. Oh, an expert, aesthetics expert. In one case, this called everybody they could find. They found one person who was available, $18,000, and he generally works only for developers or the Department of Public Schools. The Department of Public Service, they hire their own aesthetics expert. I tell the neighbors you're better off if they don't, because I've only ever seen one case where the department's experts have found an undue adverse aesthetic effect, and that expert just died. Several tower cases, they hire a firm from New York. They don't even come over here. Balloon tests. You asked about a balloon test. Are they required? No. So balloon tests, usually the company does one, but they don't notify anybody. Or maybe if the town asks for them to come to a meeting, they'll have the balloon test first. Then the company will come and present simulations. But if you're not sharp to know that you better get out there and look at all the vantage points and get your pictures. We've had a couple of cases where nobody saw the balloon. And once the application's filed, the neighbors said, well, can we have a balloon test? And Greg Faber won't require it. And the company says, well, the landowner won't allow it, so we're not going to make them do it. So there's no balloon test. So now you can't even have your own balloon test to find out where it's going to be, so you can develop your own aesthetics simulations. So back to discovery. So generally it's about a week or 2 after the scheduling order is out that you have to submit your discovery questions. And then usually the applicant takes a week or so to submit their discovery responses. It doesn't matter what type of case, whether it's telecom or solar or wind, it's very rare to get anything useful from the applicant out of discovery. They just don't answer the questions. They say, oh, see this in our application. And then you have not a very long time to file your own pre-filed testimony. And so then you have to have, maybe Allison will file her testimony about it affects her property, and John will file his testimony about it affects his property. But you also can sponsor witnesses. If you can find a witness on the criteria that you are given standing on. Now, this goes back to why it's so important for the towns to intervene. We have tried in one case to allow citizens to have standing on coverage, because these coverage maps and these claims about coverage appear to be pretty inaccurate coming from the companies. I've heard this over and over, that they overestimate what they claim they're going to be able to cover, and they are making claims in the body, the sort of the presentation at the beginning about what the coverage will be. But then when you get into the actual data, it doesn't support what they say. So in one case, we were able to find an independent expert, which is very hard to find. And the department can hire an expert, but they're almost all work for industry. But we did find somebody with really good qualifications who said look at what the actual data shows. There's not going to be the coverage that they're claiming. So only the towns, which get standing on all the issues, can bring in testimony about coverage. Also, we have a lot of issues that we hear this is going to provide public safety. And so in almost every case I've been involved in, the people talk to their fire department and their emergency, and they're like, we have coverage. And for instance, in Timoth, they can't even use the tower that's proposed there for public safety. A lot of these towns have contracts with, I think, something in Burlington. And so this is an area that I've never seen testimony on. I've never seen anybody actually present, but the citizens couldn't present that testimony. Only the town. And okay, you're doing budgeting. You're really kind of busy. The roads are going, you've got a lot of issues on your town, but they're the only ones who can present any testimony on these other issues. And if the town is taking a position that doesn't comply with the town plan, then the neighbors are really only left with aesthetics. I'm very concerned about the aesthetics of Vermont. We are not protecting the aesthetics of Vermont. There are some really badly sited cell towers already. And if we don't get a handle on this, Senator Leahy was quoted in 1998 in the New York Times saying, I don't want Vermont to become a pincushion state. And it was about telecom towers. And that's exactly where we're headed. I want to take issue with what Greg Faber said yesterday about the sunsetting of Section 248 resulting in a rush of towers applications. I see nothing to support that. What I see is we had a flurry of applications for FirstNet. AT&T built out a lot of towers, have a lot of applications. They have one application right now in Poundland. And then Industrial Tower and Wireless came to Vermont a few years ago. Worcester was their first one that I was aware of, but there were one in Fairfax and even before that nobody complained about. And they have a plan to build out the entire state. And if you go to their website, you can see their map. They have covered New Hampshire, they've covered Maine, they have these ugly lattice towers, and they only go through the process for the lattice tower with antennas on top. But somebody told me the other day that one in Fairfax now has antennas on it, but nobody evaluates the whole build out of them during the process. So
yeah, I just want to, sorry if I could just, for one moment, this is very helpful. Thank you. I know we started a little bit late. But we had you scheduled for an hour. I'm not sure how far you are through the process.
We got to keep going.
Well,
and I'll tell you, this is why it is such a challenge. I have these meetings, and it usually takes 2 hours.
Okay.
And it is the sort of thing that I generally only tell people the advance notice part until that's over, and then the petition part until that's over. And then the next part, because it's so extensive. So if you can go to 2:15, let's just keep going.
I just wanted to flag it for you because I think I hope we let you know we had an hour. I'm not trying to cut you off. I just
too long. Yeah. I can't do it any faster. I'm sorry about the technical issues, but okay. So now you're preparing your pre-filed testimony. Let's say you get it in. It's a real struggle. You've got, 6 or so different witnesses that they're putting in their fact witness or lay witness testimony. You've got some experts, you've got all these exhibits, and then you're subject to discovery. Oh, that's not fun, because then these lawyers are not easy on citizens. And in fact, this week is the first time I've ever seen depositions done in a tower case, and it's AT&T deposing these neighbors in Pownell, and then they were deposed. The discovery process is one that is used to intimidate the neighbors, and the PUC doesn't care about discovery. So this is all between the parties. And so all of a sudden, these citizens who didn't ask for this are getting, emails from lawyers. They're getting these discovery questions. They have to. The first case I dealt with had 290 questions on a solar project served on the neighbors. So why is this process like it is? A few years ago, I followed a Green Mountain Power rate case, and a light bulb went off, and I said, "Oh, this makes sense. It's about financials. You're exchanging documents back and forth. You're getting all of these. You're asking them to produce documents and admit things, and that's what this process was set up for. It was never ever set up for citing and land use issues, and nobody ever came in when all these other types of projects came in that affect land use and said, hey, we should look at how we're doing this, because this is not as far as I know, and this was said by the former public advocate, Jeff Commons, in the Act 174 public meeting. Vermont's the only state that has a PUC that does land use study. So lawyers, I got a call from one guy who said that he had called 20 or 30 lawyers in the state to try and find a lawyer to represent him at the PUC. And he said, nobody would take the case. And I said, why? He said, well, they say that it's such a legalistic process, and besides, you're going to lose. And they treat the lawyers just as badly as they treat the citizens. So there's no point. I mean, I didn't go looking for that, but it's true. There are hardly any lawyers who will do this. There are hardly any aesthetics experts to find. The department has the same problem. It's just not a viable way to do land use. So you're served with these discovery questions. You have a deadline. You get your discovery responses in. Then that leads to, oh, wait, motion practice. And so they'll file a motion to strike your testimony a week before the hearing. They'll file in the Westmore case a motion in limine to strike all the public comment, which included the recommendation from the town, and that was all struck. At one point, one of the neighbors said to me, when do we get to be heard? And I thought about it. I said, you don't. There's no public hearing. There's no site visit, which I think is outrageous. That there's nothing like a site visit. Former environmental court judge said the absolute best part and most important part of his job was the site visit. Until you get out of the site and see it, you cannot imagine what it's like. So, okay, you go to the evidentiary hearing. What's an evidentiary hearing? It's all cross-examination. So let's say you're representing the planning commission and you submitted your testimony. So, okay, on page this and this of your testimony, you say this, and could you please tell us this? The whole purpose of the the evidentiary hearing is to elicit statements by the other side that support your position that you can use in your brief. So if you will admit, if you're the developer, and you will admit that this can be seen from a neighbor's house, then when I'm putting together, or you're putting together your own brief, then you're going to say, in your findings of fact, this can be seen from so-and-so's house, and then you have to cite to the transcript. So you go through this very strange hearing that nobody ever has done anything like before. You have this cross-examination, and then at the end of the hearing, you set the schedule for briefs, and generally it's 2 weeks after the transcript. What's a brief? Anybody ever written a brief? Try and teach somebody how to write a brief?
Probably not sure.
I think the one in Westmore was 40 pages. I had it all here to show you, but in any case, it's long. And it involves going through all of the testimony, everything that's in the record. So at the evidentiary hearing, everything gets entered into the record. Up until then, nothing is in the evidentiary record. The public comment is never considered as part of the evidentiary record. Anyway, gets into the evidentiary record. And then the transcript, anything that came out in there, you pull out everything you can to make your case. So the applicant's doing the same thing, you're doing the same thing. And oh, by the way, the Department of Public Service is doing the same thing. And since their experts never find an undue adverse aesthetic effect, you're actually, as a neighbor, not only having to do a brief that is challenging the developer, but you're also having to challenge the Department of Public Service. You make your case, and then there's a reply brief. And that's about a week later. And with the reply brief, it's generally short. except that if you're the neighbor, you're responding to two briefs from the department and the applicant, and so yours has got to be a bit longer because there's more to respond to. And then the hearing officer issues a proposal for decision. And then you get to comment on the proposal for decision. So if it says to deny it, which has happened once, you're like, great. If it says to approve it, then you have a lot of work to do to make your case why you shouldn't be approved. You can ask for oral argument. Okay, the citizens have to go to before the full PUC, and they get 30 minutes, the other side gets 30 minutes, you make your case, and then the PUC decides. And nobody has ever done a site visit, and there's no opportunity for the PUC to ever hear from the public, at which point you're pretty much guaranteed that the project will be approved. And when you look at the final order, it will say, it says that we weren't even there. And that is the PUC process. And it's this way for telecom, with the added problem of the recommendations, but it's also this way for solar projects. And it's really grueling. When I've talked to people afterwards, to even get them to respond to requests from the PUC to say, well, what's it like? It's hardly anybody wants to even think about it again. They've used the words like brutal. Now I want to speak to what Ryan from AT&T said yesterday, because he made statements about how they really consider the community and how they won't ever do something against a single abutter. I'd like to recommend that you hear from the abutters in panel and what they've been put through for the last year by AT&T, because they've even offered a site on their property so they wouldn't have to look right out at it 700 feet from their house. And they were deposed the other day. There's absolutely nothing community minded about it. I did a visit the week before Thanksgiving, and I came back about as upset as I have been in years over what a corporation can do to a family with young children who have, lost a whole year of peace of mind and quality of life with no end in sight with this company that will not quit litigating. Now, the Enosburg case, that was appealed. The decision was appealed in federal court, the federal district court judge, and I've sent these things that will be on the website. I've sent these court decisions to the page. He cited that Senator Leahy's quote at the beginning, and he affirmed the PUC's denial, which was based on the Regional Planning Commission's recommendation. Right. I only found out in November they appealed that to the Second Circuit Court of Appeal, and that decision came out in November. And about 3 o'clock on the day before Thanksgiving, Industrial Tower Model has filed a new application, a new advance notice for a tower in Enosburg in exactly the same location, but 20 feet shorter. And that community is going to have to go through it all over again. Okay.
Yeah, first of all, I apologize. Our posted agenda says we're going till 2:30, so I just moved my meeting. I don't want to.
I know you guys have a lot of questions, so.
No, that's okay. So we have until 2:30, as we said we did. So, I guess I have a question. In what circumstances have you seen, citizens or a town have an impact or be successful?
None. The Enosburg case is the only one that's been denied.
Worcester, sort of.
Well, Worcester was advance notice. Now, when it goes through the full petition, and there aren't very many of them. I mean, keep that in mind. We don't have much of a record of contested cases. The reason we're seeing contested cases right now is because these companies are coming in with tower applications that are closer to homes, closer to village centers. Now, you weren't on the committee, Representative Sebelia was. Back in 2020, when this came up before, it was during the pandemic, and there was a proposal for a tower in Thetford. And I got calls about it. And it was very close to the historic village center. And one of the things that happened, perhaps the only thing that happened, was that the chair of the Housing and Technology Committee put in place an extension of the notice period, the advance notice period, to give the town the opportunity to work more with AT&T to find another location. They did find a location on town property. That tower is built. And it's a good example of what can happen when the people work together. Instead of just coming in and saying, this is a site, we're sticking to it, and we're not doing anything to change it. So there's a good example of one that came about through a collaborative process. And AT&T used to do that, but they seem to have changed in recent times so that now it's just, they're getting their site. And in Granville, what happened was that they applied for a site. It's on a back road. You're familiar with the Granville Gulf? I think it's one of the most beautiful drives in Vermont. This tower was proposed in very prominent view of the people on North Hollow Road, which is a back dirt road. And I don't know, half a dozen or more homes would look right out on this tower. They're looking at gorgeous mountain views. They're living in the middle of paradise and nowhere. And so they proposed to use the same parcel, but move the tower further away. So it only affected one property, and A&R came in and opposed it. Meanwhile, they were proposing to use a right of way, and we run into these land use or property issues with right of ways in other cases too. And the landowner sued in Superior Court to say you can't use this right of way. And a decision came out that would have upended all right of way an easement in the state. It came to the Supreme Court. The Supreme Court reversed it and remanded it back. The landowner was actually winning, and AT&T was just going to litigate it. And then the neighbor who had been the leader of the group who was the most opposed came down with brain cancer and died in 2 months. And it was very sad. And the landowner who was suing could see that there was no end in sight to that litigation, and he just settled, and that they got their CPG shortly afterwards. So it was A&R's opposition that moved it back, and so at some point they'll get their tower. But that's the case where actually 2 different experts came in and looked at the claims that the tower was going to provide coverage in the Granville Gulf, and the second time we really tried to look at, is there any way to meet the coverage with smaller cells? And to do a study of that would have cost about $10,000, and nobody was interested. I mean, we are trying to find solutions. I'm very aware that this isn't just about saying no. This is about saying, okay, if there are needs to be met, how can we meet these needs and avoid these types of fights that are going on and protect Vermont's scenic natural beauty?
Other questions?
You submitted a couple of one-pagers with specific recommendations, correct? I haven't had a chance to read those, but like 2 or 3 days ago.
I sent you a memo. I sent you 2 memos that are kind of they go together. Read the land use one first, then the section 248 A1 first.
Right.
I appreciated the comments you made at the end of the meeting yesterday about what's the solution here? What are your options? I do not see it as an option to simply extend section 248A or for however many years. This problem has got to be fixed if you're going to stick with it. Is it possible to fix section 248A and make it work with, for instance, directing the PUC to do rulemaking and do something about the recommendations? I mean, Greg said it takes us 2 years to do rulemaking. Well, okay, it would be in place the next time if you were going to extend it. But I think the larger issue is, and this is one in the 25 years I've been coming into this building, this is the first time any committee has ever looked at the PUC process for land use siting, for citing solar projects, wind projects. Nobody's ever taken testimony on what the process actually is. And so I said this 10 years ago to the Act 174 committee. I looked at the testimony the other day. We have a good land use law. Right now, we've got these two different sets of standards. This is in my memo. And this is the moment because of what's going on with Act 181. And I appreciate you said that Representative Sheldon could take a look at this. Is this the time to move land use out of the PUC and put it where it belongs, which is in the district commission process? The difference between the two processes? District commission, they will put a notice in the newspaper if an application comes in. Everything comes in as a minor these days, but if you want a hearing, then it can become a major. Minors are not appealable. If you have issues and you want a hearing, they'll hold a site visit. You go to the hearing, you get party status, and you can talk. You can make your case. They can make their case. You don't need lawyers. I can represent people. And then if there are, after the hearing, if there are more information that needs to be gotten from either side, the commission issues a recess memo, a recess order. So there is no discovery. And I was in the stakeholder group for the appeals, stakeholder group for the land use review board. I'm the only person who was in all four of the stakeholder groups except Lily Costa, and it was really valuable. And I heard the lawyers there talking about environmental court and what's the problem with appeals in environmental court? Motion practice and the abuse of discovery. And I realized, well, that's exactly what I'm seeing at the PUC. Motion practice and the abuse of discovery. The litigious solar lawyer, he has taught me everything about motion practice. He files every motion possible. And we're seeing that the lawyers that are currently doing these cases, except the AT&T lawyer who's been doing, he's been representing AT&T a long time. There was a similar lawyer doing Verizon's cases, but something happened to him. And so now we're seeing lawyers who've never practiced before the PUC. They're very litigious. They have experience in federal court. We're seeing a level of motion practice that is very disconcerting. And it turns out that this motion practice and discovery is also an issue in environmental court. And one of the recommendations is to limit that or minimize it, because that is a way that both sides can slow things down. So I think that the Act 250 process provides the opportunity for the parties to come together to work out the issues. They can actually sit down and talk. It's in statute that they can have informal stakeholder groups. And if people want to fight, they can go to court. But in the first instance, we shouldn't be starting out with a contested case for something that is possible to work together on. If the towns can work with these companies and the community to find good sites or find shorter towers or find a way to meet the needs. And what we're not talking about here is that the health issues are very real. What's happened with the FCC is that there was a DC's Court of Appeals decision in 2021 that directed the FCC to update their emissions guidelines because they were way out of date. They haven't done it in 5 years. And so right now they're not complying with a court order to actually consider the cumulative effects of all of this technology that we now have that were not in effect in 1996. And the oral argument in that was absolutely fascinating to listen to hear that FCC was given thousands of pages of studies that they never even considered. And so the FCC is known to be a captured agency. And the backdrop of all this is that right now the FCC is taking comment on a rule that would eliminate all opportunities for citing for state and local governments. And there's also been efforts in Congress to pass something that's completely stripped all citing. But I will tell you that my efforts in the past in this body have been met with, we're preempted on everything, there's nothing we can do. And right now, we do have the authority to look at citing, and I think that there are better ways to do it than what we're doing.
Other questions for it?
Just to comment,
Yeah.
thanks for your detailed on the ground reporting. Um, it does sound like a really, difficult process for an average person.
I will add that I met with Chair McNamara in September of 2024 and went through this for 2 hours with him. I took him through I said, I want you to understand what it's like for the public. And he said that he was open to trying to change the PUC's process to be more like the district commission. And I saw him again in June at a site visit, and I said, okay, do you want me to submit a petition? What do you want me to do? And he said, well, how about another meeting? And I never heard from him. And I can't keep doing this. I hope I gave you a headache. I mean, this is enormously stressful. I've given the same explanation of the process over and over and over again. And then, 15 years ago or 10 years ago, I was in this room with Tony Klein sitting in that chair. And I said, I feel like I'm leading the lambs to slaughter. And 10 years is a long time to do that. And then to be accused of being anti this or anti that, because I'm trying to help people have a say in what goes on in their communities. We have been successful in stakeholder processes with OMIA, with Cabot Agrimark, with JP Carrera and Sons. Everything changes when you sit down and talk. And that we start these cases with a fight. There are better ways to do things.
Yeah.
So
Oh, God. Oh, my God. What is wrong with you today? Go ahead. But Graham was first.
Oh.
It's like twice. My head is, I'm going this way today. I don't know why. Jeez. Representative Kleppner.
The chair may be giving me a hint that I'm not picking up on.
It's drifting left today.
So 248A, cumbersome process, and going to the district commissions moves all of this citing from 248 back to 250, which we've also heard is a very burdensome and complicated process that nobody likes.
There is a lot of mythology built up around Act 250. And I have been attending, as I did with the Climate Council, I've been attending all these meetings that the Lord was having. I'm one of I might as well be their mascot at this point. The chair calls on me, Annette, you have anything you want to say? You're much nicer than they were at the Climate Council. I've attended all the public hearings. I've attended all the meetings they've had with their commissioners and coordinators. And in every one of these meetings, something has been said about, we're getting blamed for Act 250 permitting. If you look at their data, they're very good at getting decisions out. The district commission process is the best process we have for, it was envisioned to be like, people sitting around the wood stove at the country store and let's work things out. It could be considered like the advance notice process, where you actually have a formal way that you can get together and talk. And so Act 250 is also, we have to do all this engineering and all that. Well, these companies are doing everything that they would do for an Act 250 process. But then you wouldn't put the citizens in the position of having to be involved with the lawyers, and it wouldn't be a whole lawyer's game necessarily.
We heard from Chair McNamara and that since 248A has been in effect, the utilities have all chosen to do that. No one has chosen 250, and I wonder if it actually is better for everyone. Why are?
Oh, I didn't say it was better for them.
Well, one would think sitting around and getting it sorted out would be better for them.
Well, actually, it isn't true that they're not still using Act 250. I know Greg Faber said that yesterday, but if you actually, there's a whole other issue with the lack of a consistent database. There apparently is a statute, I found it at one point, that told Act 250 to create a map of all of the towers that have been proved that they haven't done the map. So when I need to look at something like I had to look at Manchester, I think, I found that for existing towers, where they have already gotten the Act 250 permit, if they're adding or swapping out antennas, they will be using Act 250. So Act 250 is still used. I think when I was on the Rutland Regional Planning Commission, we dealt with a tower proposal then. But why do they choose to through Section 248A? Because hardly anybody participates, and when you do, you're going to lose anyway. And so, of course, the industry likes it. It is definitely a biased industry favored thing. Now, what would it mean for the companies? It also would mean municipal permitting. I don't think there's anything wrong with having to go get a municipal permit. Is it going to add more time than the long time that these cases are taking through the Section 248 process when they are contested? There's not, I mean, I don't know why the developers want Section 248 for energy cases for solar. It must drive up the cost. You could do it so much faster. It's, a lot of these cases are about where to plant the trees. You don't need lawyers for that. And we also haven't talked about small cells. I need to touch on this. And there's a page with some pictures on it. There's a lot of small cell deployment going on in the state that is not regulated at all. They're being put on existing phone poles. They are pretty loaded up with things. I sent some pictures to Hunter Thompson recently. He didn't know about them. We need some regulation around small cells because they're putting these things up in front of people's homes. It could be next to a baby's bedroom. There's no notifications. The de minimis and the limited size and scope stuff, that's got no public process at all. You asked about decommissioning. These towers, once they're in, they are forever. They don't come down. So that's why it's so important to have them sited well, because they need to go in a place that minimizes the impacts to the environment and to people. This is not easy. People are asking, well, if we have all these satellites, what do we need this for? Public safety, I think distracted driving is a problem. I don't think we should cover all of our little winding back roads where people can be looking at their cell phones. With the fiber optic build out, areas that don't have cell coverage, everybody has cell service in their houses. They just use the Wi-Fi off their house or they use VoIP. So getting to what is the need? What is it that we're trying to do here? Vermont is never, the one thing Governor Shumlin said that I agree with, Vermont is never going to have universal cell service. Because of our mountainous terrain and topography, we are never going to have it. And they're unrealistic.
Representative Bailey?
Yeah, so I was getting back to what Rep. Kleppner was talking about, the time frame. So if you have a contested case through 248A, if they actually figured it out that they did the advance notice and or going through the 250 process, is there, can you give me a type of time frame, one versus the other? Out to
The data that I've seen from Act 250 is much, much shorter. I would have to, there's probably somebody better to answer that question. In fact, there are three people I recommend you hear from in addition to the neighbor from Pownell. Brooke Dinglebean was an attorney who did both the Enosburg and Granville cases, and she is now on the Land Use Review Board. So she has this expertise in both areas. She can get you data on these things. Timoth, the town clerk, is the one who's dealing with an ITW tower right now, and that has some very interesting nuances to it that have revealed this problem with the recommendations. She was a representative here in this building for 6 years, so she would be an excellent witness. She said that she would do it. Her name's Gail Fowler, and so she understands what you're trying to do and probably could come up with some good ideas. And there's a lawyer who started to do this work, Andrew Clyburn, and he's currently representing people in Marshfield and in Timoth, and he would like to testify, and he has some ideas. So I don't know what they are, but those are three people in addition to the citizen in Pownell who would give you a better understanding of.
We have someone coming from Westmore, so.
Oh, good.
So.
and just one other follow-up.
Yeah.
Are you recommending that you put all the tower process through Act 250 or just the medium and in the big months.
Certainly when it's a land use issue, it belongs in Act 250. I've been recently thinking, what business does the PUC have? What is their interest in telecom? And where should antenna siting be? Now, here's the problem. Every other state but Connecticut does telecom regulation through municipal zoning. So what I'm seeing is that municipal zoning can write standards for small cells. They can do setbacks from people's homes. It can establish some aesthetic standards. They can do things in municipal zoning. Because we have this section 248A and this strange way where you can use your telecom bylaw for your recommendations, people aren't, there's no mechanism for looking at small cells. So we're seeing other states have the rights. California, Massachusetts, their municipalities are writing bylaws that actually address small cells. The technology is changing. So I think that the combination of Act 250 and municipal zoning would enable us to, I mean, my town doesn't have a telecom bylaw. It relies on Act 250. I have no doubt that it would go faster through Act 250. Now, if it's going to a contested case, if everybody wants to fight, then you're talking court. And
Through 248 or both
they're both,
processes.
yeah, but I think that small cells also belong in a way that communities can have a say. And currently they can't at the PUC. It's rubber stamp for all that other stuff.
Right. Thank you so much for being here and for.
I could give you more of
testimony.
the stuff that I have if you want it. I mean,
I have a lot of, I feel like I have a lot of documents for you, but anybody is welcome to reach out and
my
submit.
problem is I have too much information. So
Yeah, I mean, what you send will post.
and you should look at what I did in 2020 and what I did in 2023. Because if you just kick the can down the road and I come back in 3 years and nothing happens, I mean, what am I doing? Just get me a brick wall that bang my head against. I don't know. It's like I really appreciate the 3-year sunset and the opportunity. But if it's just going to be let's look at it and then let's just move along, we'll look at it again in 3 years. Now's the time to fix something. You can go big picture, you can go little picture, but something's got to change because this isn't fair to our people, especially with the power and the money that these corporations have, with all the political might preemption that they have, that they are using against our communities. So thank you very much.
Thank you very much,
Thank
Annette.
you.
Appreciate you coming in. Alex?
Yes.
So we can go offline.